In terms of 5, this is another aspect of contract law. This is employment law. And really, an employment contract is almost like any other contract. The only real difference with an employment contract it is often for an indefinite period of time. Most contracts have a start and an end point, right? Employment, however, tends to be long-lived, unless it's a predetermined length of time for a job. But a lot of permanent jobs go until you retire or until some change in the work environment. So that's what really makes it unique, is the duration of it. So we're going to look at the first major issue that you should be aware of is, how can you tell if someone's an employee versus an independent contractor, and what implications does that have? We're looking at this concept of vicarious liability, which is a liability that is imposed on the employer because of the actions of the employee. We're going to look at this concept of negligent hiring, which is either you hire under the employer hires someone under a false premise. I've hired you to be a bookkeeper, but I'm going to get you to paint my house. Okay. Or if you are an employee and you say that you're a doctor, a medical doctor, and it turns out that you have no credentials whatsoever. That's what we mean by negligent hiring. We'll look at the elements of an employment contract. What are some of the key essential ingredients there? And in the event that those essential ingredients are not in place, how are they put in place by the courts? We're going to look at this offer and acceptance of a job. We're going to look at expressed and implied terms. And expressed terms means that they're not necessarily written down, but you would assume that that is the case. You would make a natural assumption, whereas, an expressed term is something that's written down. An implied term is something that you would assume is the case. We got to identify the contents and terms of an employment contract. Look at this issue of termination. What kind of termination do we have, and what are the implications depending on the type of terminations? We would think of dismissal, for example, with cause, or dismissal without cause, dismissal with notice, dismissal without notice, and the concept of a constructive dismissal or a wrongful dismissal. And we're going to look at the damages that result from those constructive wrongful dismissal type situations. And we're going to look at, we looked at a few of the cases, and I can look at the cases again this morning. So this concept of an independent contractor. Okay. Effectively, you have to be able to ask yourself, is there an employment situation going on? Do we have a hard relationship that is long-term? And if we have a hard relationship that's long-term, we would more likely suggest that it is employment. We look to several signs to see employment. For example, in the payment of a salary, are deductions for taxation, employment insurance, Canada pension plan, are those withdrawn from the paycheck of the individual? If those things are taken out, it's an employment relationship. Okay. We also look at to say, well, what's the net effect of a job? Are the tools supplied, for example? Does the workplace supply a desk, a computer, and all of these sorts of things? If it does, it's more likely employment. If the person got to supply their own equipment, then it's more likely an independent contractor. So these are some of the tests. Now, those tests, when you get into taxation and things like that, Revenue Canada, or Canada Revenue Agency as it's called now, has specific things such as that need to be checked off to determine whether or not an employee is an employee or an independent contractor, and what the obligations of the employer are then to withholding taxation and CPP and the like for the purposes of taxes, and be able to write that stuff off. Now, so if we look at employment, we'd say it's a master-servant relationship, meaning that someone's in the boss chair and someone's in the servant chair whose job it is to serve the boss. It's very much of an agency type of relationship. This relationship is normally associated with a contract of employment. The contract does not need to be written, but it is helpful, like any other contract. So what happens is that contract says that there was an offer. I offer to work for you for an amount of money to do a certain thing. And the acceptance of the employer, okay, I will hire you to do a certain thing for a certain amount of money. So one person really works for another to do that work. So there's all kinds of legislation that is out there around employment, because where it's a long-lived contract, there are many problems or issues that can arise during the term of the contract. So what governments have seen fit to do is to develop a series of legislative boxes or structures, we'll call it, to support the employment contract in the event that contracts are not full and complete. The issue of an independent contractor comes into when we say that there is no employment contract whatsoever. An independent contractor is totally different than employment. That person that does that work comes, does the job, and goes. There's no long-term commitment. It's specific for a specific purpose, specific reason. So as I mentioned to you, Revenue Canada has some of these tests, and these tests are, some of them are discussed here. This is not a complete list of these tests. All I wanted to do was to demonstrate to you that for the purposes of legislation out there, the legislation is helpful in determining whether or not an employment situation and an employment contract actually exists. The primary one is something called control test. And the control test effectively says is that the master controls the servant. The master tells the servants what to do, when to do it, how to do it, where to do it, and you know, the parameters of the job are well defined. If that is the case, when we say the master has a lot of control over the servant, and in this case, you would suggest that this is what is defined as employment. So controls the ability to, and the authority or the right of the payer to exercise control of the worker concerning the manner in which the work is done and what work will be done. So when examining control, it's important to focus on both the payer's control over the worker, daily activities, and the payer's influence over the worker. And in most cases, the relationship is based on continuity, long-term, loyalty, security, subordination, or integration is characteristic. So are you part and parcel of the organization? Now, independent contractors, there's no real control there. You know, independent contractors control their own hours and how they work. No one's telling them when to do it. Employees work under the direction of the employer. Independent contractors do not. Employees tend to have a long-term relationship. Independent contractors do not. As I mentioned too, Revenue Canada also states that we have something called the tools test. Do the tools get supplied by the employer, we'll call it? And if the tools are owned by the employer, then we tend to have employment. More likely, it is considered an employment relationship. Independent contractors bring their own tools. We also have this issue of financial risk. Another key thing that Revenue Canada will look at, is there a risk? As an independent contractor, I could do a deal for you and lose money on it. Okay, I could say, okay, I'm going to plow your snow all winter. I'll charge you $20 for it. It cost me $2,000. Well, you know, that's business, right? You made a contract. We agreed to the price to do the work for all winter. That's it. But the fact of the matter is, if you're an employee, you cannot find yourself in that situation. An employee will never lose money or incur any risk in the job because they will get paid. The agreement says that I will pay you for hours of work or a salary or these sorts of things. So there's no risk. Responsibility of investment and management. The CRA also considers the degree of responsibility for investment and management held by the worker. How much responsibility did the worker hold for the dollars and cents and the amount of time and energy and effort invested? If the management of that is really in the employer's position, then it's an employment relationship. If the management of that is really in the independent contractor, it is an independent contractor. The other thing that's mentioned is this part and parcel of the organization. Are you integrated into the organization? Do you have a seat, a parking spot? Do everyone know your name? Are you there every day? These sorts of things. So we've lots of cases like that. The next thing that we looked at was what are some of the obligations of the employer. So you need to be aware of what these obligations are. You know, an employer's job is to make sure the workplace is safe, make sure that there's appropriate direction, in other words, good management, make sure the tools are appropriate, make sure the wages are paid and that they're clearly defined, reimburse for expenses. The employee has some expenses need to be reimbursed. Any other requirements included in the employment contract. So for example, the contract could say there's a medical insurance program. You have to provide those. The employee has responsibilities as well. The employee has to be reasonably competent. Reasonably competent. You know, can you fire someone for screwing up mildly? No. Can you fire someone for screwing up wildly? Yes. So reasonably competent comes in there. Have the skills claimed. You can't lie on your resume. And for example, if you said you're a medical doctor and you're not, that could undermine the employment contract because really it was based on false pretenses and the employment will be done. It will be a dismissal with cause, very much. Be honest, punctual, and loyal. We talk about this fiduciary duty again. Perform the work agreed. And sometimes there's such a thing as a restrictive covenant. That's a word that gets put on some employment contracts. And these are tricky. These occur too often. Effectively, what a restrictive covenant says is that in the employment contract, it says that once the employee leaves a place of work, so let's assume that I work for you, we have a contract, and in that contract, it says there's a restrictive covenant that says I can't snowplow for anybody else. So I'm snowplowing for you. That's the contract. I leave your place of employ. You fire me. I quit. One or the other. We end the contract. And I go out plowing snow for someone else. And you say, well, hold on a minute. Now, you said in that contract that you wouldn't go work for anyone else. Well, the question is, how restrictive is a restrictive covenant? In the case of that, what you're doing is limiting my ability to earn a living. So the restrictive covenant, the court would look at that and say, that's too strong. You cannot do that. However, if the restrictive covenant was that I can't form a competing business for yours. If you own a snowplowing business, I'm just an employee, and I can't form a competing business for you within 6 months of that type of restrictive covenant could potentially be held. And if I started a company immediately, you could sue me, and the courts would probably rule that I'm not allowed to start that company. So restrictive covenants are really tricky. But effectively what it does is it's a post-employment agreement. So once I leave your place of employment, I can't do something. We also talked about termination. Now, termination is really what the crux of all this employment thing is. You know, employment contracts are written all the time. They work perfectly. People do their jobs and everything's happy. What happens is people end up in court because of this issue of a failure of the contract. Something causes the contract to break down, and when the contract breaks down, the employment relationship is broken. So here we are now looking at some of the broken issues, okay? So termination, an employee, for example, could be terminated. So an employment contract may provide for its own discharge. So within a written employment contract, it could say that at any point in time, the employee can leave, or at any point in time, the employer can fire the employee with 2 days notice. Those sorts of things. You can write that in a contract. So when a contract is for a fixed term, say 1 year, and that term expires, the contract is over, the job is over. Or when the parties have mutually agreed to bring it to an end. You and I both agree that, no, this is not working, so we mutually agree to bring it to an end. We can do that. Under common law, though, you must give, if it's not written down, you must give a reasonable termination notice, meaning that the employer has to tell you, the employee, beforehand that we're going to terminate the deal, or the employee has to tell the employer that they're going to terminate the deal. So reasonable notice is that gray area. How reasonable is really what comes up. So what ends up in court is, was there enough notice given? And then we got this issue of just cause, and can't forget that. If something fundamentally breaks the contract, then that's just cause. Someone lied, someone did something so heinous. the fact is that there will be no notice required under just cause. The question is, proving just cause is challenging. And oftentimes, just cause in one's opinion will not be just cause in another's opinion. So just cause is always a bit of a nuisance. So effectively, you end up giving termination warning or leaving warning, I'm going to quit warning to your employer. And that needs to be in a period of time that's reasonable. What's reasonable? Well, reasonable is often defined in the contract, 2 weeks notice, 1 week's notice. And if it's not defined in the contract, you'll find it in statute. So basically, the longer you work for someone or the longer that you're employed by someone, the longer the notice. That's generally how it goes. You can leave right away, or they can kick you out the door right away, provided that they pay you in lieu of the notice. So if you're required to have 2 weeks notice, they can simply say, see you later, but pay you 2 weeks salary. Okay. And we get into this issue of reasonable notice, and as I say, the Employment Standards Act lays out some of the terms of that. You run into this issue of potentially falsely letting someone go, or wrongfully letting someone go. So employer's right to terminate employment, even with proper notice, is further restricted by human rights legislation, Charter of Rights and Freedoms, which prohibit termination when it amounts to a discrimination on the basis of physical, mental disability, gender, religion, color, and other protected grounds. So notice periods, as I say, notice periods are gray. The court system has looked at it. Common law notice period maybe up to 2 years if it's long employment and it's a very difficult job to replace or a very unique job. So all these things. Statutory periods is less, but common law prevails. If, for example, the statutory says you only have to have 2 weeks notice, but if you've worked there for a long time and it's a unique job and there's not a lot of jobs around, you could argue that it's actually more than that. So what defines just cause? Well, just cause, there's no notice of termination required for it. This is where very specific problems would arise. And these problems would include being dishonest with the employer or acting immorally, convicted of a crime that interferes with your ability to perform the job. A bank teller, for example, who is convicted of fraud is probably not going to be employable by a bank anymore. Disobey lawful instruction by the employer. Now, that one's a bit gray too, because if the instruction puts that person at some sort of perceived risk, you have the right under occupational health and safety law to refuse, provided you feel that your life is in danger. It has to go through a process, though. If for example, you feel that you're in danger of this, you say, oh no, I have the right to refuse. What happens is a process happens where a union representative or some employee of the company would come in or a department official would come in and review it and say, yeah, you're right, this is dangerous, you don't have to do it, or no, you're not right, you have to go do it. Committed an actionable wrong on the job, that could be any number of things, or lied on a resume. Incompetence is possible. You could be absolutely incompetent at your job and your employer can say, no, I'm going to get rid of you because of that. The question is, if you worked there for 20 years, why didn't they let you go before? So incompetence is a bit of a gray area, but generally, if you can't do the job, you can't do the job and you're let go. Unacceptable conduct may not constitute just cause. It could be very serious. It's very difficult to put a finger on exactly what is unacceptable as definition. The other issue of inability to perform the work. If I require my eyes to do the job and I suddenly get blinded, that's inability to do the job. The question is then, yes, strictly, I can't do the job anymore, but you have to look at human rights legislation. Is this unreasonable? Is firing me unreasonable? Can you make provisions? And the employer has to make all kinds of provisions for me, right up to the point of undue hardship before I can be let go for just cause. Now, an employer can let people go because of lack of work, economic downturn. Still, they have to give reasonable notice. We look at the issue of wrongful dismissal too. Wrongful dismissal is when you are dismissed for the wrong reasons, usually involves disputes over whether or not adequate notice was given or whether just cause was achieved. The claim is, the claim that you would go to court with is that there was no just cause or that it wasn't enough, period. Very unlikely would you get to go back to work. So any harm to the employee's reputation may increase the notice period required, and must also factor in benefits that go beyond the salary in terms of loss. The thing is, when you are wrongfully dismissed, if you're on the wrong end, if you're on the butt end of this, your job, according to the courts, is to minimize your loss. In other words, you got to look for a job right away. If you're relaxing in Florida while this is processing, someone's going to say, did you do everything possible to mitigate losses? And as I say, reinstatement is usually not an option. After the bad blood that's created by this type of disagreement, it's very difficult to go back. The other issue that you should be aware of is this issue of constructive dismissal. So constructive dismissal is very much focused on the fact that you did not get fired. They did not let you go. They didn't do away with your job. They just changed it so much that fundamentally you could no longer do it. Okay? So, things like if, for example, you're working in St. John's or you're working in Claremont, they tell you have to go to Tahiti in order to keep your job, and you say, I don't want to go to Tahiti. Would the reasonable person pick up and go to Tahiti? You could effectively argue constructive dismissal because they took you and they moved you, or they told you your job was gone to some far-flung place that really made it very difficult for you to go to that far-flung place. An effective demotion, meaning that, well, you used to be the president and now you're the janitor. You're making the same amount of money as you always made, but you're going to say, effectively, you've taken away my job and constructively dismissed me. So fundamentally, we got a very strong change in the condition of employment that you feel, if you're on the butt end of this, has fundamentally changed the job so that you can no longer do it. And that could be grounds for what's called constructive dismissal. And it is effectively firing you without firing you. You can sue then for wrongful dismissal in this case. And the employee's obligation is to mitigate the loss, as we've already talked about. And the employer should communicate with employees and try to identify appropriate arrangements whenever there is a need for changing like that. If the employee leaves, the employee can quit. There's nothing wrong with an employee leaving an organization, but the employee still has responsibility. So what can make an employee quit for cause? Well, quit given dangerous or illegal instructions, not properly paid, put in a dangerous situation, can no longer perform the duties due to disability or illness, or important information of employment contract was breached. The contract may provide for notice. For example, my contract could say that the terms required for notice are longer than the statutory. And that is the case for the college instructors, for example. The statutory says 2 weeks, 3 weeks, 4 weeks, depending on how long you've worked there, whereas our contract says it has to be 4 months. Usually we run into a situation where contracts go beyond the minimum standards in terms of the notice period. And the employer will be, the employer or the employee could be liable if they leave before that contract period is up. It works both ways. When you do leave, you can't take confidential information, customer lists, secret formulas, or practices. Again, that's confidentiality, and you cannot breach confidentiality, and you cannot persuade customers to come with you. Even though you do see it happen where, for example, hairdressers that would leave one place of employment, move to another, will often end up taking their clients with them. And you must comply with restrictive covenants if they're legal. In terms of wrongful hiring, we also talk a little bit about that. Wrongful hiring is really employer misrepresentation or employee misrepresentation. It's one or the other. So in the case of employer misrepresentation, wrongful hiring exists when the employer induces an employee to join an employer based on misrepresentation of job duties and positions. So wrongful hiring is based on the tort of negligence or fraudulent misrepresentation. An employer should not overstate the importance or status of the position. Employees accept positions based on the description given. And if the description given is wrong, there could be a case of wrongful hiring. In order to bring a wrongful hiring case, the employee must show a reliance on the misrepresentation when making decisions. So you left one job in Calgary, for example, to come to St. John's to go to work. And when you got to St. John's, the job wasn't as was described. That would be a case of wrongful hiring, employer misrepresentation. And you could not only sue for damages with regards to your work here, but also the fact that you left your other job and came all the way across the country for it. And you got to suffer some sort of loss. So the employer then is responsible to third parties. And we talked about this vicarious liability at length. You should be familiar with vicarious liability. And, you know, these things are running into potential problems. So you should be aware of that. Injuries, employees' injuries, if an employee is hurt on the job. We have a system in Canada called no fault, and that effectively is the workers' compensation system. If an employee gets hurt on the job, the employment of the employee is still guaranteed, but what happens is that the workers' compensation entity of the province, so for example in Newfoundland it would be the Workplace NL, they would effectively pay the salary of the employee while the employee is recuperating. Okay, so you know, and so the cynic would say that employers started up the workers' compensation system because they're the ones that fund it in order to prevent themselves from being sued. And that is true. You can't sue your employer anymore because of this. But the supporter of the workers' compensation would argue that we can guarantee that employees will get compensation regardless if the employer disappears or not. So workers' compensation provides compensation to workers injured on the job. It eliminates the dilemma discussed above. Workers' compensation is no fault, so we're not pointing a finger at someone. Employees covered by government act are entitled to compensation under the act, must waive the right to sue, and employers contribute premiums. So that's that first section. The second section really looked at employment legislation. Here we're looking at employment standards. Now there's employment standards in Canada and employment standards in each of the provinces. So we looked at Canada and Newfoundland here. So in terms of Canada at the national level, if you're a federally regulated employer, employment standards are the minimum standards established by law that define a guaranteed right in the workplace. All employers are free to meet or exceed the minimum standards. However, they cannot contract beneath the minimum standards. Like other legislation, each province and territory in Canada has its own legislation. About 90% of Canada's workforce is protected by employment laws of the province or territory, and the remaining are covered by federal. So it's about 10%, 90%. Employment legislation cover rights in areas such as hours of work, overtime pay, minimum wage, vacation time, public holidays, coffee and meal breaks, pregnancy leave, parental leave, and termination. So the Newfoundland Employment Standards Act is what applies in Newfoundland, and labor standards clearly lays out what is good and what is not good in this province, and it lays out the minimum levels. Okay, so the legislation sets out the minimum terms and conditions of work, including hours of work, overtime, holidays, vacation, and leave. Establishes the basic rights and responsibilities of the employers and the employees. So there is a guide, and you can take a look at that. But what I've done is I've taken the guide and kind of summarized it here. So the Labor Relations Agency is the entity that looks after the Employment Standards Act. And here are some of the things there. So there's a benefit, for example, a guaranteed benefit that there will be a certain number of paid public holidays. In Newfoundland, there are 6: New Year's, Good Friday, Canada Day, Labor Day, Remembrance Day, and Christmas Day. And there are qualifiers. So if you work it, for example, and what level of entitlement you have. So you have to work 30 days prior to in order to get the day. In terms of vacation pay, you got to work there for 5 days before you start eligible for it. Effectively, for the first 15 years, they put aside 4% of your gross income, which is equivalent to 2 weeks. So you get 2 weeks off with pay, basically. And after 15 years, you get 3 weeks off with pay, which is equivalent to 6%. And the fact is paid one time before. Vacation time. Again, you have to work a full year before you're eligible for vacation time by legislation. Sick and family responsibility leave, you can get eligible for this if you work for 30 days and it's 7 days unpaid leave. This has become a big issue in the world of COVID, for example, as people can't afford to be off because they're not getting paid. Pregnancy leave, same sort of thing. If the critical thing for women is they have to be employed 20 consecutive weeks prior to the leave, and they got to give 2 weeks notice, and then you get 70 weeks unpaid leave. Parental leave is the bit that comes after pregnancy leave. Pregnancy leave is only available to women. Parental leave is available to both men and women. And again, you have to be employed 20 weeks, and you can get up to 61 weeks of unpaid leave. I think 61 weeks plus 17 weeks will equate to the year and a half or year and a bit. Adoption leave is almost the same as pregnancy leave in terms of the lengths. Bereavement leave. Bereavement leave been criticized in Newfoundland. You get 1 day off with pay, 2 days without pay, so your total 3 days off. And again, it's just 30 days, and there's a descriptor there of who's your relation that you can get bereavement leave for. Compassionate care leave. This is very similar to child care leave. This is usually for taking care of older adults. This has become more important over the last number of years as our population ages, and you get up to 28 weeks of unpaid leave. Critical illness leave, that's kind of a new one that's been added on, but same basic type of situation where someone is sick. If you're employed for 30 days, you're eligible for 37 weeks of unpaid leave off to take care of a child, 17 weeks if you're taking care of an adult. Crime-related death and disappearance, this is a very new one. And again, it is hopefully something that everyone, and none of us will ever have to use, and that's where you have a child abducted through some crime or some criminal related event, and that's time that you can get off for that. Reservist leave is a rather new one too. It came up during the war in Afghanistan. There were a lot of reservists, people who are part-time military, who were called up to go there with the Canadian Forces. And when they came back, they didn't have jobs. So one of the things that the legislation did was change to reflect the fact that if you're in the Canadian Forces and you're a reservist, you are entitled to get your job back when you come back. The federal government is paying you while the employer doesn't need to pay you because you're getting paid by the federal government when you're on duty. There's another one there for family violence leave too, and it's 3 days off, 7 days without pay. Communicable disease, and again, very similar to the COVID situation here. Again, same sort of thing. We talked about notice of termination and the time frames. As I say, it is legislated. So if you've been there less than 3 months, you're not eligible to any notice, but you don't have to give any notice either. So this is, very much the when you're on some form of, period of time that the employer can decide whether or not they want to keep you. 3 months, you get 2 years. 3 months less 2 years, you get 1 week. 2 years, less than 5 years, you get 2 weeks notice. 3 weeks notice with 5 years to 10 years. 4 weeks notice, 10 to 15 years, and 6 weeks notice after that. So we talked too about hours of work, and that is, there's 7 days. You got to have at least 1 day off. Hopefully it's Sunday. You can't work any more than 16 hours a day. 40 hours is a standard work week, of which anything beyond 40 hours should be paid overtime, which is 1.5 times the minimum wage. Breaks, when people are eligible for breaks, so after 5 hours, you get 1 hour. Okay, if the employer requests that you stay beyond, you got to get paid for it effectively. And minimum wage defined there in Newfoundland right now, with $12.50 an hour. Vacation pay, we talked about that and what comes out of it. That's just a detail of it. Legal deductions from wages, you talk about things that can be legally deducted. Most common are the income tax, Canada Pension Plan, EI. International law really is when you do business abroad. And the real question from a legal point of view of whose laws apply, is it my country's laws that apply or the other country's laws that apply? So this has become very important now because of the internet. We're doing business very easily across international borders because the internet has meant that those borders are not really important anymore for doing business. So we've got a situation where countries have laws, and realistically, the laws of your country may not apply in another country. So that creates the problem. So we got to be able to determine the major crux of the concern is that which jurisdiction is applying and how are we going to enforce it if we do know which jurisdiction. Okay. So the legal system is evolving here. The laws are in place, but not readily adaptable. Governments have been reluctant to introduce regulatory and control, but that's now changing. Okay. So the internet doesn't recognize borders, and generally a particular location can exercise jurisdiction if the defendant is resident there and if the action underlying the complaint took place there. So all it means is, look, if the deal was made in Canada and you're in Canada and the other person's in Canada, Canadian rules apply. So long-arm statutes may allow jurisdiction even when non-resident is involved. Long-arm statute means that it will go past borders. So sometimes there's agreements between countries, Canada, US, Canada, Mexico, Canada, Great Britain, that would allow for these things to happen. It depends on the particular situation. So right now, the better approach is to allow jurisdiction action only where there's a close connection between the jurisdiction and the act complained of, and may help the state to contract which jurisdiction governs a transaction. It's very helpful whenever we get a transaction to say that the laws of Canada or the laws of the United States or the laws of whatever apply in this case. Particularly in Newfoundland, we've got some consumer protection legislation, the Newfoundland Consumer Protection Act, which provides rights for anyone located in the province at the time of transaction. Foreign judgments may be hard to enforce, as usual. So one of the biggest problems that's come up internationally is domains like www. That's been a bit of a problem. And the internet world has created some international world intellectual property organization to handle and manage that. In terms of torts across the international boundaries, we got certainly defamation, and that's created a problem. The internet service provider has been found liable in some of these. So Facebook, for example, people spreading hate, that's been a bit of an issue. And if the Bell system or whoever is the internet service provider allows those messages to flow through, then oftentimes they could end up in court. So effectively, then we got to be very careful with international rules. So the Uniform Electronic Commerce Act was developed by the federal government, and the provinces have basically adapted that, and it has laid out what we need to do in order to be able to write legal contracts internationally. Again, you run into this fundamental problem. It doesn't apply to all documents. The fact of the matter is, it's very difficult to enforce. So we do have online contracts. I don't know if you've ever had to do this, but I have signed contracts online. And right now, businesses may state the law of a specified jurisdiction, and then people got to click accept of that on the online contract. Once they accept that, once send is hit, we assume that that is acceptance. So those are some of the key things that you should be aware of there. And as I say, there's a lot of more iffy than any real clear guidance on this. Okay. So that was the major core of the things there that you should be aware of, is that there are challenges doing business internationally. The federal government, provincial government have created regulations related to how contracts can be enforced. And even then, we're running into some problems. Okay, so jurisdiction is important. And these international treaties have been put in place. So part 2 really looks at more of a practical approach here, and that is intellectual property. Intellectual property relates to stuff that is created by human ingenuity. Okay, someone either comes up with a great design, someone comes up with a beautiful book, a song, artwork, whatever. It's human ingenuity that draws that, and the question is, how do we protect it so that nobody can claim it as their own when it's not theirs? So there's a whole bunch of intellectual property legislation, and that property legislation tends to be broken down into some major categories. First, there's copyright, and when we think about copyright, that deals with artwork, written documents, and the like. Next, there's patents. Patents refers to some sort of a legal provision for practical things that are inventions. And then we got trademarks, which is kind of like, again, similar to copyright, but it is names of businesses, logos, and like that reflect to business. So intellectual property law is kind of an umbrella for all of those. So the first one that I wanted to bring you to was the Copyright Act and what effectively it does. So copyright is 100 years old in Canada, and it gives protection for written documents. So it extends to the authors and artists to the end of the calendar year in which they die, and for a further 50 years. So effectively, if it's a written document or something that can be copywritten, a song that emerges out of a written document, effectively, the writer of that document or the creator of that document or creator of that song has the rights to it 50 years past the date of their death. Okay? And that means that the estate of the person will get any revenues for it or has control over ownership of it. Once 50 years has passed, then it goes into public domain, unless it's protected some other way. So the owner of the copyright controls reproduction of the work for the period after which the work becomes part of the public domain. So it gives the owner a monopoly. So effectively, the whole idea of copyright is to give a monopoly, and effectively it is for patent and trademark too. It gives that oneness, someone has control over it. Now, there's always a balancing act that government has to do. It wants to create innovation, so it rewards people for coming up with great ideas by giving them this monopoly, but it also wants to encourage the diffusion of the innovation. So this is why these contracts come to an end, or these things are shortened, because people need to be able to move forward and revise, change, build on, employ these things. So it's some sort of a neat little balancing act that government has to do. Copyright covers these basic things: literary works, dramatic works, musical works, artistic works, performances, sound recording, communication signals. And if you own the copyright, you basically have power to draw all the revenue from that and control it. You can sell the copyright to somebody. You can say, okay, you can go do that, or and you're going to get some revenue off of that, or you're going to receive some. The thing is, though, you don't sell the moral rights to it. The moral rights give you still, the creator, the control over how that product is used. So no one can take it and distort it or change it or use it for a purpose that you didn't want it used for. One of the other problems that comes with copyright is fair dealing. Okay, so I'm in education and I want to show someone the cremation of Sam McGee. So if copyright holds, I can't show them that. I can't load it into my computer and throw it over the internet like I'm doing here now. So what we got is a fair dealing provision in copyright that says people can use it, provided that they use it for certain purposes. Education, satire, parody are allowable fair dealing, for example, as well as research, private study, news reporting, criticism, and review. Okay. If we run into infringement of the copyright, it is the copyright holder's responsibility to deal with the infringement by taking it to court. So the copyright holder is responsible for that. You don't register a copyright, so you're the one that got to be vigilant on your copyright. The other major issue is the patent, and a patent really is a protection for a industrial design or product that you come up with. And trademark is a little mark or a physical symbol or brand that is protected as well. These things have a limited life too of 20 years, and they have to be registered. So you should be aware of those. So we got acquiring the patent, you go to the patent office effectively to do that. And acquiring a trademark, you have to go and apply for that as well to register it. And there are legal and cost implications to trademarks and patents. Now, I had to get quick on that in order to ensure that I got it all covered. But those are the major topics that will be discussed on the exam.